So, what happens when you're injured on the job? If a workplace hazard leaves you unable to work, is your employer still legally bound to compensate you? In this week's Query This, Chantae McNeil looks at your rights and what to do if your employer says no.
Query this. You're a construction worker on site. When disaster happens, you slip and fall 4 stories from a scaffolding, fracturing your leg and injuring your spine. You're later declared disabled, but instead of continued support, you're prematurely dismissed from your job. Compensation is cut off. What steps can one take if this happens? Is this action by an employer fair? What should the employer's duty be to you in such a scenario?
Me say them don't want to pay no money, so then lay you off. Yeah. So you have to take the step and seek advice, like a legal aid clinic. It's not fair. It's not supposed to happen like that. When you're working at a place, so they're supposed to insure workers.
There is other vacancy where I can be employed or put in another area. I think if they could do that, and if they don't want to do that, well, they need to take care of my expense until I can work again.
You have another choice more than get a lawyer or the place downtown name a Minister of Labour and check them.
The employer should assume the responsibility because it was on the job, especially if it's a case where the proper precautions weren't in place for you to not be injured.
We took the matter to attorney at law Priscilla Duhaney, who explained that under Jamaican law, including Workmen's Compensation Act, injured employees are entitled to compensation once the incident occurred on the course of duty.
He would be eligible for both special damages compensation in terms of monetary compensation, which is usually categorized in terms of special damages and general damages. Special damages covers the expenses that he can prove, pretty much the medical expenses that he would have to pay out of pocket. As it relates to general damages, you know, you're looking at that which you cannot literally find, you cannot specifically outline how much this particular expense costs.
While mediation or out-of-court settlements are options, Duhaney recommends pursuing legal action if they aren't getting any satisfaction. But she warns workers not to rush into quick settlements, and here's why.
A lot of the injuries that persons experience, you can, within a short space of time, you cannot assess it completely. If you do this within a week or 2 and say, all right, you're going to settle with your employer, then you might be, accepting something that is significantly below what you are really entitled to, because the injuries might not surface, or the extent of the injuries might not surface till months or even years later.
As for the worker's dismissal after the injury, the attorney says that's an unfair labor practice that happens far too often. Victims are urged to seek help from the Industrial Disputes Tribunal. But if that's not what you desire,
then of course litigation would be the next best bet for them to reinstate you as an employee, as well as to continue to compensate you while you are reinstated in the position as an employee.
And that's it for this week's edition of Query This. If you're facing legal issues and don't know where to turn, email me at cmcneil@cvmtv.com. I'll help you find the answers to the questions you have. Until next time, I'm Chantae McNeil.